Any questions at all? No? Okay, so let's start unit 4 because we're going to do 4 and 5 today. Janet, you have a question?
No, I don't.
Okay. Thought you had one. Okay, so last class, anyone want to do a recap of last class? Classification of trust. Where we learned about different types of trust. And recall that the names are not written on the trust deed. I hope everyone got a copy of the trust deed. I think Ms. Dean says she sent it out.
I
Yeah.
didn't. Archer, I got a copy of the trustee, but it's missing 3 pages.
Oh, Lord.
So
Okay.
sections, I think 7 to 13, sorry, 6 clauses 6 to 11 are missing. There's 3 pages that aren't on there.
Okay, clauses 6 to 11.
I didn't receive it.
Who's that? Who didn't receive it?
Melissa.
So? Okay, let me send a note to her now before we begin. So she can resend it. Hold on 1 second. Let me send this. Okay, who want to do a recap of unit 3 while I type this message? Who did it? Who did review? Who read? All right, so I sent her a note. Okay, so let's go to unit 4. Since no one recapped, no one bothered to read their notes. Was it a very busy week this week?
Yes, for me it was.
So no one had a chance to go over. That's fine, that's fine. So let's start unit 4, which is on the validity of trust. So we know from the very beginning that there are 3 parties to the trust: the settlor, the trustee, and the beneficiaries. And we know that the settlor himself has no rights over the trust once it has been properly constituted, unless he makes himself a beneficiary. We know that the beneficiaries themselves have a right because they have the equitable interest in the properties, or as we call it, the corpus of the trust. The trustees have the legal interest in the assets that are in the trust. We also know that a trust can be created for many different reasons, or give the trustee many different powers. And sometimes the powers that are given more or less determine the type of trust that it is. Sometimes it depends on the powers or the way in which the instructions are written. You can tell the type of trust that the settlor wished to create. And so we spoke about discretionary trust, where the trustee has the power to make the decision as to who receives income and who receives capital. We also spoke about revocable, irrevocable trusts. We spoke about trusts that are executed, fully executed. We spoke about trusts that are not completely constituted, charitable trusts that are for charities. We also spoke about purpose trusts. Which other trusts we spoke about now? I'm trying to remember all of them. Secret trust, a half secret trust, a fully secret trust. And so all these different types of trusts, the example I gave you is an asset trust. Remember from the very first chapter when we started, we said a trust can be established for many different reasons. Some of them is for asset management, some is for wealth preservation. Some is just to take care of their children. Some is to avoid probate. So instead of waiting a year or 2 years for the probate registry to settle the actual assets, you can actually have a trust where it's continuous. We also spoke about a trust being created within a will. And so all in all, we have established that there are many different types of trusts. But now today we're going to talk about what makes a trust valid. So, hold on 1 second. So we know that the trust itself is a legal arrangement, and the settlor transfers the title of his property to the trustee for the benefit of the beneficiaries. So what makes a trust valid? And to know whether a trust is valid or not, there's certain things that have to be in place. One of them is that there must be 3 certainties. The second one is that the formal requirements have to be in place in order for the trust to be created. And the last thing is the transfer of the subject matter of the trust by the settlor to the trustee in accordance with the formal method. So that means that if the settlor is transferring shares, then the shares have to be transferred in the manner in which they should be. So that may mean signing off the back of the certificate. If it's the shares of a company, that means a resolution has to be formed, and then the shares are transferred at the back, and then it has to be recorded by the company secretary in order for it to give effect. So every asset has a different method of transference. And so the trustee has to make sure that the assets are transferred to him properly in order to say that the trust has been constituted. So today we're going to focus on the 3 certainties. And the 3 certainties focus on certainty of words or intention, certainty of subject matter, and certainty of object. Now I given in the notes here the case of Knight versus Knight, where Lord Langdale gave the importance of the 3 certainties. And he said, as a general rule, it has been laid down that when property is given absolutely to any person, and the same person is, by the giver, who has given the power in it to command, recommend, or entreated or wished to dispose of that property in favor of another, the recommendation, entreaty, or wish shall be held to create a trust. First, if the words were so used that upon the whole, they ought to be constructed as imperative. Secondly, if the subject of the recommendation or wish to be certain. And thirdly, if the objects or persons intended to have the benefit of the recommendation or wish also be certain. So in the case of Knight versus Knight, it determined that the 3 certainties must be present in order for you to say that you have a valid trust. So let's look at certainty of words or intention. The question always comes before the court as to whether or not the settlor intended to create a trust. And that is borne in mind when you think about the maxim, equity looks to the intent rather not the form. So that means that there's no precise expression to determine whether or not a settlor had the intent to create a trust. So what the court looks at is the words in the trustee, or they'll determine whether trust can be construed from those words. So even though sometimes the word trust may be in a provision in a will, that doesn't necessarily mean that a trust is being created. So the court will look at the words used in the document, and then they evaluate the obligation of the trustee to determine whether or not that obligation is, I guess, sufficiently imperative to amount to a trust. So in the case of Re-K Ford, a mail order company in financial difficulties, it sought some professional advice. on how to protect customers' money sent to it for goods, and the aim being to avoid them falling into the hands of the liquidator. And a special account was opened at a bank, and it was called a customer's trust deposit account, into which customers' monies were paid pending fulfillment of orders. When the company went into liquidation, there was some money in the account, and the question arose whether this was held upon trust. The court held that there was a trust, since the whole purpose was to ensure that the beneficial interest in the money remained with the customers until their orders were dispatched. So in certain cases where there are no documents to evidence the alleged trust, certain words spoken or the conduct may show that a trust was intended. And that's what Rike 4 demonstrates. In the case of Stewart versus Fields, the testator's will contained the following clause: I hope it will be possible to create a trust after I am gone to ensure that this land remains forever in the hands of the Stewarts, and that my nieces and nephews always have the above interest, which can be passed on to their heirs and successors. The testator also added clauses that any proceeds derived from working the land should be distributed among his nephews and nieces and aunts, and that at no time should the land be the son's to sell. The court held that the testator intended to create a trust for the benefit of his son and relatives identified as beneficiaries in his will. So it is important that the courts distinguish whether the settlor has the intention to impose a binding obligation, as in the case of a trust, or whether he's just using the words of anticipation or expectation, and which may not be the intent to be binding. So that means that when someone writes a clause in a will or someone is creating a will, the court always looks at the intention and whether there is a binding obligation. And you can tell that either by the actions or by the words. In a leading case of Adams v. Kensington Vestry, a testator left all of his estate, quote, unto the absolute use of my wife, in full confidence that she will do what is right as to the disposal thereof between my children, either in her lifetime or by will after her decease. The court held that the gift to be absolute, because listen to the words and the way in which he wrote it. He said, unto the absolute use of my wife. And then he said, she has the right to dispose of it. So when he used that word absolute, the case posits that the words used to create a trust must make it plainly clear that a trust is intended. So that word absolute means that it is hers. She could spend all of it in her lifetime. She doesn't have to leave anything for her children. Just by inserting just that one word in there. So after the certainty of words or intention is certainty of subject matter. So that means that the settlor must know his assets. He must know which property he's going to put into the trust. And he has to be certain as to the extent of the beneficial interest of each beneficiary, which means that he has to determine who's going to get income and who is going to get capital. It's important that there is certainty of the trust property, as it allows the trustees to know exactly what will be included in the trust and what will be excluded from the trust. The beneficial interest of each beneficiary must be certain in order to enable the trustees to know exactly what and how much each beneficiary will be entitled to receive on the distribution. And in addition to who's going to be paid income or capital, the trustee also needs to know who and how much is he going to accumulate for certain beneficiaries. In the case of Boyce and Boyce, a trust failed for uncertainty as the beneficial interest, where testator left several houses on trust for his wife for life, and on her death, to convey any one house to his daughter Amy, as she might choose, and the remaining house to his daughter Betty. So Amy died before she could make a choice. And so this left uncertainty as to what house Betty should receive. And so the trust for Betty was void. In the case of Spring versus Bernard, the testatrix left 300 pounds to her husband for his sole use. And after his death, the remaining part of what is left, and he does not want for his own wants and use, to be divided between her brother and her sister equally. The court held that this was not a trust for the husband with remainders over, but rather an absolute gift. There could be no certainty as to what could be left for the brother and the sister on the husband's death. So he was entitled to spend all the money himself. In Hunter versus Morse, Morse declared himself a trustee of a 5% holding in the issued share capital of a company totaling 1,000 shares. Morse was the registered owner of 950 shares. It was held that a trust of 50 of Morse's 950 shares had been created. The court rejected Morse's argument that the trust was void for uncertainty of subject matter, in that there was a failure to identify the particular shares to be held in trust. The court took the view that the certainty of subject matter does not necessarily require segregation or appropriation of trust property, as all the shares of the same category and equally capable of fulfilling the trust obligation. The court held that for certainty of subject matter was satisfied. So this example is, let's say someone has 1,000 shares in Commonwealth Brewery, and they want to create a trust, and they say that 50 of those shares, of the 1,000 shares, are to be held in trust for my daughter. All of the shares are the same, unless of course he had 1,000 preference A shares, preference B shares, and then common shares. If it's just one particular share that he has, then the court will be able to determine that yes, there is certainty of subject matter. Also note that if there is some uncertainty on the subject matter of the whole trust, there may be some doubt as to whether the settlor intended a trust at all. So that means that the subject matter is one of those critical elements that has to be present in order for a trust to be created. Now is certainty of object. An object refers to the beneficiaries, and the beneficiaries must be clearly defined, or there has to be some formula in place whereby the trustees can determine who are the beneficiaries. So where a person is named, for example, Helen, or upon trust for my friend Mark Roll and cousin Angela Fox, the requirements are satisfied. But then of course, there are some persons when they're writing a will, or if they're creating a trust, if they say my old friends, or my defendants, or my friends. And of course, once you make those general comments like that, then there is uncertainty of objects and the trust will fail. So the ascertainment of beneficiaries is an important requirement to enable the trustee to administer the trust in accordance with the terms and also to discharge their duties. Because if they don't know who the objects are, then it's going to be very difficult in order to make disbursements. So there are different tests for certainty of objects if in a fixed or discretionary trust. For fixed trusts, the test of certainty of objects is that it must be possible for the trustees to prepare a complete list of all of the beneficiaries. And if this is not possible, then the trust will be void. For discretionary trust, the test for certainty of objects is whether it can be said with certainty that any individual is or is not a member of a class. And therefore, the trustees of discretionary trusts are only required when exercising their discretion to be able to determine if any person who they are contemplating to give a benefit to, whether it's income or capital, is or is not a member of that class. So the leading case for that is MacPhail versus Dalton. In the McPhail case, the settlor wished to establish a trust for the benefit of the staff of Matthew Hall and Company Limited and their relatives and dependents. He did this by way of a discretionary trust for the benefit, quote, any of the employees or ex-employees of the company or any relatives or dependents of such persons in such amounts and on such conditions as the trustee should think fit, end quote. It was argued that the trust should be declared void because it was possible, unless it was possible to make a complete list of all the employees, ex-employees, their relatives and dependents. It was argued that a complete list was necessary because, one, the trustee's duty to distribute could be performed only if he were able to consider every possible claimant, and two, if the trustees failed to carry out the distribution, the court would be called upon to do so, and it would only do so on the basis of equality is equity, which would require a complete list. So both of these suggestions were rejected by the court. The case demonstrated that the test for certainty of objects relative to discretionary trust and trust powers is that it should be possible to say with certainty whether any given individual is or is not a member of a class, and the trust will not simply fail because it is impossible to ascertain every member of a class. And this is referred to as the postulant test. In applying the test, the description of the class does not be so obscure as to preclude the trustees from determining whether any given claimant is within the class. So an example of obscurity is when you would say any person having a moral claim on the settlor. That could be anybody. So you can't determine who it is. Or any old friends. Who could that be? The court also imposed other limitations on the test. That is, a discretionary test will be invalid if the definition of the beneficiaries is so hopelessly wide as not to form anything like a class. So in the case of McPhail versus Dalton, it determined that you can have a wide class, but it has to be determinable. If it isn't determinable, then the trust itself will fail for lack of certainty of object. So the McPhail versus Dalton was applied in the Bahamian case of Re Butler, Oakes versus Butler. And in that case, the testatrix made the following provision. I give and bequeath unto my trustee to divide amongst such of my friend and relatives living at the time of my death, the jewelry, fine art, and other personality then owned by me, in such shares and quantities as my trustees may select and appoint to them. Any such jewelry not so appointed by my trustees shall be disposed of as part of my residuary estate. It is my hope that in making the said selections and appointments, my trustees will be guided by such suggestions I have made during my lifetime. And the court held that the certainty of objects was satisfied as a relative of X was a person who could trace descendant from a common ancestor with X. The court applied the guidelines set out in the Barlow Wills Trust to define friends as a relationship, which must have been of a long-standing one. The relationship must have been a social one, as opposed to a business or professional one. And although there may have been long periods when circumstances prevented the testator and the applicant from meeting, when circumstances did permit, they must have met frequently. And so the court determined what the meaning of old friends meant. And of course, a family member was able to trace how these persons were actually friends of the deceased. So whenever the trustee is in doubt, then they turn to the courts. So in addition to satisfying the three certainties, the settlor's legal interest in the property has to be transferred to the trustee, like I said before, in accordance with the formalities of the trust. The object of the trust must also be lawful for the trust to be validly created. In order for the settlor to transfer property, he has to first own the property, and he must have the necessary capacity to do so. And capacity means that in law, capacity means that you must have the requisite age to dispose of property. So that means that you must be 18 years or older. And capacity also means that you must have the mental capacity. That means you must be of sound mind. A settlor may also create a trust of the equitable interest in certain properties as well. Minors may hold an equitable interest in real property, but they do not have a legal interest in such property and cannot create a trust of a legal interest in land, since no such interest can vest in or be vested by them because they are in a minority. Minors may create trusts of the equitable interest in property, and such will become voidable for the purpose of the law until the minor attains the age of majority, which is 18. Like a will, when it comes to legal requirement for mental capacity, it is necessary for the settlor to demonstrate that he fully understood the nature of what he was doing, that is, creating a trust, notwithstanding the fact that there may have been some mental incapacity previously. In the case where a trust may have been created by a settlor with a history of mental incapacity, it is sufficient to prove to the court that the trust was created by the settlor during a lucid interval. And that rule also applies to when a person is creating a will. A person may be insane sometimes and may have what we call lucid intervals. And in those lucid intervals, they can create a will. And so it's the same thing with creating a trust. Now, whenever you could create a trust has a duration. And in the rule against perpetuities, it states that the grant of a contingent interest is void at the moment it takes effect at common law, unless it is certain that the trust will vest, if it vests at all, within the perpetuity period, which consists generally of a life or lives in being, that is, the lifetime of the persons alive at the date that the gift comes into effect. So it's when the grant takes effect plus 21 years. So the two fundamental requirements of the rule against perpetuities are that the property must vest in the recipient of the gift within the perpetuity period, and the property must not be limited and be rendered inalienable. So if there is any possibility that the gift will not vest within the perpetuity period, then the gift will be void. Or alternatively, the court used what they call a wait and see, whether the gift will be void by salvaging the portion of the gift that doesn't offend the rule against perpetuities. In certain circumstances, and considering the events after the commencement of the trust instrument, which may be applicable to vesting of future interest, that may also be the interest to be valid if the contingent event occurs within the perpetuity period. So the perpetuity period starts at the date the trust instrument takes effect, which may be the date of the testator's death, if the gift is by will, or it will take effect from the date of the instrument. Then the period terminates after the lifetime or the lifetime of the life or lives in being plus 21 years. The rule against perpetuities relates to future gifts on the trust created by will or an inter vivos trust, except where the following applies. If it is a gift to charity, it is exempted. If it is a trust for any fund that is registered under the superannuation and other trust funds, or where there's a right of redemption under mortgages, and where their future personal obligations are not within the rule. So prior to the Trustee Amendment Act and the enactment of the rule against perpetuities abolition, the perpetuity period in the Bahamas was either 150 years from the time the gift is made, or the time period consisting of a life or lives in being at the time when the gift is made, plus 21 years. So in the section 11 of the Trustee Act, which amends section 71, the power holder has the power to amend the perpetuity period. And alternatively, the court has the power to extend or increase the perpetuity period, up to 150 years from the date of the creation of the trust, upon application by the trustee, particularly in circumstances where there is limited or no power to amend in the trust instrument. The rule against perpetuities abolition abolishes the application of any applicable rule against perpetuity. And this rule against perpetuity is automatically abolished for dispositions that were created after the 30th of December 2011. For dispositions created before that, the trustee must make an application to the court to declare that the rule against perpetuity has been abolished by virtue of the application. So after the recent legislative changes to the perpetuity period and the rule against perpetuity, the applicability and usefulness of the wait and see and the inalienability doctrines remain to be seen and may be tested by the court under new provisions. Any questions?
I have a question, Ms. Archer.
Go ahead.
Can you give an example of a gift that will not vest within the perpetuity period so that it would then become void?
Okay, let me see if I can think of a way. Okay, let me see if I can think of an asset. Well, the first thing you have to think about is the interest itself, the person to whom it is going to be given to, their interest is contingent. So contingent means that it's premised upon a certain event happening. And whatever event that is that happened has to happen within that period. Now I'm trying to see if I can think of one. And none is coming to my mind. I'll have to think for a while. Let's see if I could think of a gift that won't fall within the perpetuity period. Because it is lives and being plus 21 years. I'll once I find one, I'll tell you. I'll send you an email.
Thank you.
I have to think. I'll think about it. Okay. Any other questions? Let me write it down now. Everybody understands the 3 certainties? So the exam questions would normally be examples of either a trust being created or a trust within a will being created with words. And then you have to determine with words or actions, and you have determined whether or not a valid trust has been created. So it'll be similar to the examples that are in the chapter, but different. So no questions.
So you're saying that we would have to reference the cases?
Yes.
Oh.
Hold on, I'm trying to find an example for you right now before I move on to the next chapter, so you can have an idea. Hold on, give me 1 second. What do you mean? Oh, yes. Let's see. Let me see if I can get one. All right. So say, let's say a trust is created and the settlor declares a trust but he doesn't identify the bank account. Right? And the bank account itself has changed. So let's say he had a regular account at the bank. But over time, the account changed to an interest-bearing account. And so in his will now, he's creating a trust in respect of bank account so-and-so. Do you think a trust will be created? If the
No.
form of the trust has changed?
The information has changed, so the type of account has changed. And then the account number has changed.
Yes, yeah.
So it states uncertainty because how do we know exactly if this is the account or not?
Right. So that lacks certainty of subject matter.
So I have a question to add on to that. If he had said, just generally any bank accounts that are found to be my own would be put in trust, would that then constitute an actual trust?
Any bank accounts are said to be my own. That's rather vague. He could put that, you could make you could add that if you leave that as residuary. You know what I mean when I say residuary?
I think so.
That's at the end. Normally you
that's-
stipulate exactly what you know to be yours by name. And then at the end, you have a residuary clause. Anything
Okay.
else.
Okay,
Right.
gotcha.
Yeah. But you can't make these vague comments and expect a trust to be created. Or even if a trust is not being created, if you're just in a will just making a disposition, it can't be vague. You can't say, I devise my piece of property over in the eastern area. It doesn't work like that. You have to say lot number so-and-so situated at so-and-so.
So they have to revisit these trusts or wills to make sure that the information is relevant as time go by then.
Yes, yes. And that's why you see
Ms.
people, go ahead.
I have a follow-up question with regards to the account that changed.
Uh-huh.
Even though you can trace the funds back to the initial account, and the intentions of the new account was to continue the operation of the old account, that's still uncertain?
Yeah, but see now, when you create this document, right? All of that is not going to be there. All it's going to say is that this is your bank account. This is what you put in your document. So that's why I'm saying is, yes, you'll be able to trace it, but it will most likely fall in residuary because it has to be clear. For the trust to be created, those three certainties have to be there.
Okay.
So it's not going and looking around to find it. Yes, you look around to find it, but it most likely will fall into residuary. Let me give you another example. If I can find one that. Okay. If let's say someone is creating a trust and then they say, it is my desire that she allows $10,000. No, let's say it is my desire that she allows Peter an annuity of 25 pounds during her life. Does that create a trust?
I would say yeah, because it states clearly exactly what she wants to do. Right?
No,
But then Peter can be anybody.
no, it ain't Peter. Remember now, when you talk about the validity of trust, you're looking at three things: certainty of words or intention, subject matter, and object. This one is now looking at which one of the certainties. It is my desire that she allows Peter an annuity of 25 pounds during her life. That's looking at words or intention. Just those words, it is my desire. Are they creating a trust?
No.
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 because-
Because
Okay.
it's just that word.
Yes.
Because a
Right.
desire or my wish.
Yeah. So that's what you have to look at. When I give you these examples in the exam, look at, if I ask you, are these phrases or are these clauses valid? The first thing supposed to come to your mind is the three certainties. Once you see the word validity, that's pointing to the three certainties. And that is what you use to apply to the phrases that I will give you. But on the last class, I will tell you what's coming on the exam, but there will be some of those. That's always there. Just to make sure that you actually understand it. Any more questions? Think about it before I move on to the next part. Just in case. This is our last class.
Ms. Archer,
Yes.
so you're saying with the phrases, if I wanted to create a trust, I can say, I cannot say that, it is my desire to create a trust for my kids. Or something like that.
No. Think about it. Think about it. Say to yourself what you just said. It is my
is my
desire. No. The law works on intention. What's in the mind? It's my desire means that you're thinking about it.
It could be something else, okay.
Yes. Yeah. I'm not too sure.
It has to be very plain and clear.
Yes.
I want to create a trust for my kids.
Yes.
That's it, okay.
You can't be like in between because you're not too sure.
On the fence, okay.
Yeah. You have to be sure. So that's what the three certainties are about. So don't forget now, in addition to that, I could actually give you a question with validity where I am not pointing towards the three certainties, but I could be pointing you towards whether or not the assets, the subject matter was actually transferred to the trust properly. Because remember, I gave you an example earlier. It depends on the assets. The transference of the subject matter depends on the asset itself. So that's another way the question can come. As to whether or not it's being transferred properly.
Give us a
Someone
scenario. Give us a
Okay,
scenario.
the scenario was the one I gave you already. Let's just say it's shares in a company, because that's the easiest one to use. So let's say the settlor has some shares in I don't know, Finco. So he now wants to put that in a trust. He can't just take the share certificate and give it to the trustee. He actually has to go to BISX and he has to fill out all of the necessary forms in order for those shares to be transferred from himself to the trustee. So let's say he has some trusts and some shares in a privately held company, a company that he manages, but he's also the shareholder and he has 50% of the shares. If he's deciding to put his shares in trust, again, he has to follow the formalities under the memo and arts of that company. So he has to go and take the share certificates, advise the company secretary that he's going to put his shares in trust. Then the shares, the back of the shares have to be signed over to transfer from him to the trustee. Then the company secretary has to record that on the register of shares, that the shares were transferred from him to the trustee. And then they have to change the register of members because it's going to move from his name now to a trustee. So every asset has a different way in which to change its ownership.
So, Ms. Archer, in terms of land or property, that would be, it has to be conveyed to the new
Yes. it'll
owner,
have to be-
but the
Mhm.
conveyance will also have to be recorded, right?
Yes, yes.
Okay.
Question with regards to the shares. So
Mhm.
if I am transferring my shares to a trustee,
Mhm.
but I still want use of my dividends or whatever, then I'll have to say I'm gonna be a beneficiary and get these dividends until I die, blah, blah, blah.
Yes, yes.
Okay, okay.
Yeah. Mhm. You got it.
To me, like when I read in the chapters, I feel like all the powers that the trustee has is kind of like the settler doesn't have much, even if they name themselves as a beneficiary.
Correct. And you know why?
No.
Okay. So when we looked at different types of trust, that's one that I forgot. This is not a
Mhm.
type of trust. When the settler retains too much power, then they say that the trust itself is a sham, it's a fraud. That is
Mhm.
not the purpose of a trust. The purpose of a trust is not to give the settler a lot of powers. Then he might as well keep the assets himself. The whole purpose of giving it to a trustee is for the trustee to administer and manage. So he
So what if
cannot have a lot of control.
what if things change?
Like what?
Right. Let's just say 10 years later or 15 years later, who I have as my beneficiary or my class of beneficiaries, the relationship isn't the same, or things have changed, or someone has passed away,
Mm-hmm.
and I want to make some changes. I have
Mm-hmm.
fixed, what you call it, fixed, where they have it fixed where exact amounts goes to whoever. So it isn't up for discretionary for the trustee, right?
Okay. So the settler can make himself a protector. He can appoint himself as a protector. And when he appoints himself as a protector, he can give himself the power to change the beneficiaries.
But if it isn't stated in the trust, then
That won't
basically,
be happening. No,
wow. So
no.
then with the trustee, when you go underneath this company and you hire a trustee, you have to cover all aspects. So you're trying to say everything that could possibly happen, every different scenario has to be put into the trust instrument to make sure.
Not explicitly. Not explicitly. You give the trustee certain powers. And within those powers, he makes certain decisions. Not
So
all of it is spelled out.
he could say that, you know what, no, we ain't changing this.
The trustee?
Mm-hmm.
But don't forget now, when he's making his decision as to whether he's changing it or not, he always must do what's in the best interest of the beneficiaries and the trust as a whole.
Mm-hmm.
So his deliberations would be around answering all of those things. But when the settlor sets up the trust, he would have stated who the beneficiaries are. And some of those beneficiaries could be a class. It could be my grandchildren. Or when they say it's my heirs. So they look at the settlor, his children, his children, his children. And he won't go outside of that class. Now, if you appoint a protector then makes sure that the trustee is carrying out and administering the trust the way in which it's supposed to be done. But the protector can also advise the trustee on certain matters. And if the protector is the settlor, then he can give advice. But again, it's determined by what's within the trustee. Otherwise, they will have to go to court.
Wow. Okay.
Yeah. So you'll see when we did different types of trust, we spoke about revocable and irrevocable trusts. So that's why some persons have a revocable trust. So when they decide that they don't want those persons to be the beneficiaries anymore, they just revoke the trust.
Okay. So that all boils down to what type of trust you would want to go
Yes.
in to choose. Okay.
Right. Yeah. I mean, it's if you have a lot of assets, it is a good arrangement to get into. But of course, with that asset, you gotta have the amount of change in order to pay the fees. Because there are fees to be paid for someone to administer and manage your funds. But you don't have the headache of even running your companies. Because underneath the trust, then you would create a holding company, and underneath the holding company, you would have all of your business entities. And when those business entities declare dividends and profits, it goes up through the holding company and then to the trust. And then the trustees would pay the income beneficiaries and then retain what's for the capital. So it's a structure for asset management, for wealth management, and also, like we say, for probate. Because when it's a death of a person, it doesn't stop the trust from performing. Anything else you read and you have questions? Now is the time, don't be shy.
Ms. Archer, I have a question where it talks about the trustee. It should be noted that a trustee may not be remunerated for his services unless authorized by the trust instrument.
Mm-hmm. That's correct. You have your trust instrument there?
Yes.
Okay.
Why wouldn't, I mean, though, but I mean,
You mean like why?
why would a trustee take on something and not to be paid?
Okay, so that is the common law rule that okay. You're thinking about a formal trustee. That rule comes up where you can decide that, don't forget now, trust came up a very long time ago. And
Mhm.
when persons were going to war, they would say they're on their horse, they're getting ready to go to battle. And they'll say, I'm leaving my property in trust to you.
Oh, okay, okay,
Make sure that it is farmed. Make sure my
Okay.
wife gets the money and she's fed. And in the event I don't come back, I want you to take care of my household. And I want you to make sure my son goes to school. And I have a debt for 10 pounds over there to Sue. I want Sue to be paid. That's the kind of
Okay.
trust they were talking about. Where you're
Okay,
not
all right,
paid.
cool.
Right. Okay.
Okay, all right.
Right. So that's why you see they say now, if you want to be a trustee and you have to be paid, the clause is actually in the trustee that you're going to be paid.
All right, I understand.
Yeah, you got it now. Okay. I try not to go too much into the historical part because it's a lot. And I guess in today's world, some people don't want to hear all these things. So people go into war and ran armors and fighting and how the trust developed over the years. But that's where it came from. Okay, so let's do 5. Appointment of a trustee. So just like any other legal arrangement, in order to be a trustee, you have to be at the age of majority and you got to have sound mind and you can't be bankrupt. And since the trustee is going to be the legal owner of the property, trustees have to be the legal age, and you can't be a minor. So even though a minor can hold or create a registered equitable interest, that is voidable until they reach the age of 18. So to be a trustee, you have to be 18 or over, sound mind, and not bankrupt. There's some other features you need to have also. So a trustee also have to possess a high level of integrity, trustworthiness, commercial awareness, and due skill and care. So there are a lot of persons around here who work for a trust company who are trustees, and those people are not, let's say, they don't hang all over the place. They're very quiet, reserved persons because they have a lot of responsibility in managing other people's assets. A corporation may act as a trustee or co-trustee with another individual. And if you want to be in the trust business, like we said in the first class, you have to have a license from the Central Bank of the Bahamas, either as a full trust company or a banking trust company, or you could have a restricted licensee, be a restricted licensee with 5 or under trust, or you could be a non-restricted, which is just a full license. Or you can get an application and apply to be a PTC, and a PTC acts as a trustee of trust for family trusts. So professional trustees are often held to a higher level of degree of standard of duty and care than individuals, because they represent, by being a trust company, that they have specialized knowledge and skills in trust administration. So the duties and responsibility of a trustee are an onerous one, is time consuming, and requires full attention, skill, and care of the trustee in the administration of the trust. And of course, the trustee can insure against liability, because that's provided for in the Trustee Act. The actions and decisions of the trustee are constantly under the scrutiny of the beneficiaries and the protector, and the potential for a breach of trust action is always existent, particularly where there are competing demands from different beneficiaries. So when is a trustee appointed? At the creation of a trust, as a substitute when a trustee dies or they retire or remove, or as an additional trustee to an existing trust. So let's say you have a new trust. The first trustees are appointed by the settlor. The settlor may appoint himself a trustee, or he could appoint another person as trustee and transfer the trust property. So normally you would see that type of trust where the settlor appoints himself as a trustee when you look at American trusts. The US trusts are created that way, and they're normally done for tax purposes, more than for, well, tax purposes, because tax purposes can be for wealth preservation and asset protection. But they would appoint themselves as trustee, and they manage the whole, all of the trust assets themselves. So when transferring to trustees, the settlor must ensure that the proper methods of transfer of the legal title is used. And once the valid transfer is completed, the trust will be completely constituted and remain valid. So where no trustees are appointed, the court may appoint trustees to administer to the trust in accordance with the terms of the trust. And the trust property will vest in the first trustees of the trust and all subsequent trustees appointed, who will hold it jointly until either one of them dies, retire, or they are removed. The testator may also appoint trustees in his will. And here, the legal estate in the trust property vests automatically in the executors at his death. Where an administrator receives letters of administration, the title relates back to the death. So the fact that a trustee appoints all, the trustees appointed all predeceased the testator or otherwise cease to exist, or even that no trustees were originally appointed by the testator at all, or that they all disclaim the trust, or that the trustee appointed is legally incapable of taking or will not cause the trust to fail, even though the will may contain no provision for the appointment of a trustee. So this means that, let's say someone creates a will, and in the will they say, Mr. Teddy Smith is my executor. And when the person dies, Teddy Smith has predeceased him. And so they're saying that even though the trustees appointed all predeceased testator, or they don't exist, or that's like a company, or that the trustees who were originally appointed by the trust testators at all, or that they all disclaim the trust, means I don't want nothing to do with the trust. Or they say they're not legally capable of taking care of a trust. Or let's say it was a banking trust and now they're just a bank, so they can no longer do it. That doesn't cause the trust itself to fail. And even though there's no provision within the trust deed itself to say appoint trustees, the trust still will not fail. The executors or the administrators will be deemed to be constructive trustees until trustees are appointed by the court. And where the same person is appointed as executors and trustees of the will, once they have completed their duties as executors, the appointee automatically becomes the trustees, and the property vests in them in their new capacity. And note that where the property is land, a deed of assent must be executed in their favor. So trustees, it's important that trustees disclose any conflict of interest prior to the appointment of a trust. And there's a fundamental principle of trust law that a trustee may not place himself in a position where his duty as a trustee conflicts with his personal interest. So trust property vests jointly in all trustees, whether a trust is created individuals or by will. And the power to appoint a trustee is often contained within the provision of the trust instrument and may be given to a particular person. The trustees or the settlor may reserve the power of appointment to himself. And we just mentioned that earlier. He can leave certain powers to himself. Unless the settlor reserves the power of appointment to himself, he no longer has the power or right to retire or remove trustees from the creation of the trust. So for those who have the trust deed, what does that trust deed state with regard to appointment of trustees? Think you could find that clause? Appointment of trustees. You have it handy? Clause 9. On the top of page 397 in your asset protection trust deed.
That's one of the pages that are missing.
Missing it. Oh, God.
Yeah, it's page 395 to 397. I don't have that.
Actually, I don't have it either.
What? Hold on now. That's the most important one. Well, for this class. I'll make sure you get it. Okay, it says under A, subject to clause 16.2, the trustee or the personal representative or the liquidator of the trustee shall have the power to appoint a new or additional trustee of this trust, and any person, whether an individual or a body corporate, may be appointed, and if appointed, may act as a new or additional trustee of this trust. 2, there should be no requirement that there be no more than one trustee. And 3, the office of a trustee shall ipso facto determine and vacate it if such trustee, being an individual, shall be found to be a lunatic or of unsound mind, or if he shall become subject to any proceedings under any bankruptcy or insolvency laws applicable to him, or if such trustee, being a company, shall enter into liquidation or dissolution, whether compulsory or voluntary, not being merely a voluntary liquidation for the purposes of amalgamation or reconstruction. So in this asset trust deed, it actually gives you, tells you when a new trustee can be appointed. And then 10 gives you the liabilities of a trustee. And then 11 gives you the remuneration clause, which is called a charging clause. And then section 12, because you're missing that page. No, you have 12, eh? 12 speaks to the powers and immunities of trustees. And remember when we did, I think it was the first or the second chapter, we spoke about changing the law when you want to transfer to another jurisdiction. They have the change of the proper law of the trust also. So you will see it when you get it. I'll make sure you get pages 395 to 397. So the rule sets related to the appointment of a trustee is set out in section 42 of the Act. You have your Act handy? Plenty papers to refer to, hey. I have it set out right here. It says where trustee, whether original or substituted, and whether appointed by the court or otherwise is dead or desires to be discharged from all or any of the trusts or powers reposed in or conferred on him, or refuses or is unfit to act therein, or is incapable of acting therein, or is a minor, then subject to the restriction imposed by this act on the number of trustees. So this is what the act says in section 42. But when you read the trustee actually tells you when you can appoint a trustee. And wherever it is silent, then you go to the Trustee Act. So you wouldn't read this section first. You would read what the provisions are in the trustee. Persons nominated. A beneficiary is nominated in the trust instrument to exercise the power of appointment of new trustees may do so. So normally in some trusts, they'll actually tell you who has the power to appoint new trustees. Sometimes it's given to the trustees themselves, or it's given to the protector, or sometimes it's given to the beneficiaries. So it says a beneficiary is nominated in a trust instrument to exercise the power of appointment of new trustees may do so, notwithstanding the fact that his beneficial interest may already be disposed. Because even though he's no longer receiving a benefit, that doesn't take away from his power to appoint. A settlor of an individual's trust may nominate himself as having the power to appoint new trustees. So no matter the circumstances, all appointments of trustees must be made in accordance with the terms of the trust instrument. The appointment of a new trustee is normally made by deed of appointment executed by the parties, particularly where a new trustee has been appointed to replace a retiring trustee or an additional trustee to an existing trust. New trustees may be appointed not only by persons nominated in the trust instrument for purposes of appointing new trustees, but also by surviving or continuing trustees, or by the personal representative of the last surviving or continuing trustee by individual's trust only. The personal representative of the last surviving or continuing trustee is not required to exercise the power of appointment and may not be forced to do so. The purpose is to enable a trustee who is disclaiming or retiring to appoint his successor. Also, all the surviving trustees together or a sole trustee to retire at the same time appoint new trustees or a new trustee to act in their or his place, which could not be done if this power was given to the continuing trustee or trustee in the prima facie sense. So this means that when you have trustees, let's say you have two trustees to a trust and both of them wish to retire or both of them wish to leave at the same time, then it is in their power to appoint new trustees prior to leaving the office. In the case of Restonum settlement, a trustee had been replaced on the ground that he had remained outside the UK for more than 12 months. On his return, he sought to upset the appointment on the ground that he had not been consulted in the selection of the replacement trustee. The court held that he had no right to participate in the appointment since the phrase refusing or retiring trustee did not include one who has been removed compulsory on account of his absence from the jurisdiction. So when you read the Trustee Act with regard to trustees, you will see that once you've been out of the jurisdiction for 12 months or more, then you can be replaced. So in Brook Bank, there was a dispute between the continuing trustee and the beneficiaries as to who should be appointed a new trustee. The beneficiaries had no right to interfere in the exercise of the discretion where the legislator had given to the continuing trustees, even where, as in this case, the beneficiaries are all sui juris and absolutely entitled to the trust property, and therefore entitled to terminate the trust under the rule in Sanders versus Fortier. So where all of the trustees of a will predeceased the testator, the last of them to die is not a surviving or continuing trustee. And so his personal representatives are not entitled to appoint a new trustee. Therefore, the power is exercisable only to the personal representative of a trustee who was alive at the time when the trust came into effect. Now, new trustees can be appointed in the place of an outgoing one or as being an addition to. So new trustees may be appointed as replacements in the following circumstances: where a trustee is dead, where a trustee remains out of the jurisdiction for a period of more than 12 months, where a trustee desires to be discharged, or if he refuses to act, or he is unfit to act, or incapable of acting. That's when a trustee can be replaced. A trustee who is a minor may be replaced, and additional trustees may be appointed as long as the number do not increase beyond 4. In exceptional cases, of course, the court may appoint a new trustee as a substitute for a trustee that has died, retired, or been removed, or as an additional trustee of an existing trust. And of course, they take into consideration the wishes of the settlor and the potential trustee's impartiality and his ability to further the interests of the beneficiaries and the trust generally. And remember now, the wishes of a settlor are not legally binding, so the trustee doesn't necessarily have to follow those.
Mr. Archer, I have a question, please.
Go ahead.
And taking into consideration that a court could appoint an additional trustee, would an example of that be in a situation where there's one trustee, a single person who maybe the trust itself is too much for them to manage, so the court is thinking in order for it to be properly managed, they need to add an additional trustee? Would that be a good example of that?
The beneficiaries will have to bring that to the court.
Okay,
Yeah, the courts don't interfere in the administration of a trust.
okay,
And so for the beneficiaries to do that, then they have to be coming to saying that there is some breach of trust. The court don't
Okay.
look at a trust and say, oh, this is too much for this person to handle. No, a matter has to come before them in line with a breach of trust.
okay, thank you.
Okay, all right. So the court will also not interfere if a person has an express or statutory power to appoint new trustees, even if requested by the beneficiaries. So in the case of Chalaram and Chalaram, in determining whether the court will act with regard to the appointment and or removal of a trustee, the following considerations were made: the jurisdiction of the court, which was dependent upon the facts in this case, the interest and welfare of the beneficiaries, the actions of the trustees, those trustees who acted improperly or dishonestly, and the nature of the duties to be performed by the trustees, whether such duties were of a particular personal or delicate nature. In the case of Reed Jardine, an application was made to the court in Guyana for the appointment of a new trustee. There were no trustees expressly appointed by the testator, but the 3 executors of the will were constructive trustees for the estate. The court granted the application on the ground that there were further acts to be completed by the executors, such as protection of the remainder man against the tenancy for life, and then dealing with the remainder during the life tenancy. The 3 executors of the will were still trustees. However, the court found that they were unfit to act. So in that case, if you look at it, you had a remainder man, you had a tenancy for life, but there were no trustees expressly appointed by the testator. But the executors, once the person had died, the executors became constructive trustees. So once they would have carried out the act that were necessary as executors, then they automatically became trustees because they have to protect the assets. for the beneficiaries. But in this case, the court found that they were unfit to act. So then, of course, the court would appoint new trustees. So in the case of Retempest, it was established that in exercising its discretion in appointing a new trustee, the court will consider the following: the wishes of the settlor, the interests of all the beneficiaries, and the efficient administration of the trust. Certain categories of persons have been traditionally unsuitable to be appointed as a trustee: a beneficiary under the trust, the attorneys of the trust, and to a beneficiary. In modern times, it has been accepted that there may be an advantage to appointing a beneficiary as a trustee or an attorney as a trustee. And in making the appointment, the qualities to be included include integrity, a willingness to spend time and trouble on the trust affairs, ability to get on with co-trustees, and a knowledge of financial matters, business acumen, and common sense. Where the existing trustees refuse to act with the person proposed by the court, a balance must be struck between upholding the court's dignity and avoiding a situation where there's a serious friction between the trustees, which would be detrimental to the administration of the trust. So after being appointed to a trust, the trustees are advised to take certain actions to ensure the preservation and protection of trust assets. So the first thing that they have to do is they have to review the trust instrument. They have to ensure that they're aware of all of the terms of the trust. And in particular, they have the knowledge and they know all about the provisions in the trust to avoid a breach of trust. They need to review and inspect the trust instrument, accompanying the trust instrument, inclusive of the trust accounts, the notices, the memoranda, and the trustee minutes. They have to make sure that the trust itself has been properly stamped. They have to make sure that the assets are properly conveyed. In addition to reviewing and inspecting the trust instrument and documents, it is important that the trustee ensure that the trust has been properly constituted, make sure all of the formalities are being carried out. So while the transfer of the trust property requires a reconveyance of land, a share transfer of shares, change in the ownership of bank accounts, the trustee must ensure, subject to the terms of the trust instrument, that he has legal ownership and control of the trust property as soon as is practicable. The trustee must also ensure that he invests trust funds promptly to minimize the risk of loss, because otherwise he can be sued for breach of trust. He must also inspect the trust to ensure that there are no previous breaches of trust, which may make him liable as the new trustee, although he may have obtained a deed of indemnity from the previous trustee, indemnifying him against any previous breaches or trust upon his appointment. He may still risk exposure to a breach of trust action, as in some cases have decided that the deeds of indemnity may not go as far as to protect a newly appointed trustee. So particularly those who fail to discharge their duties promptly and responsibly. So remember that now, whenever you take on a brand new trust, you have to review the trust deed, the accounts, the minutes, and you have to make sure that you invest the assets and you invest them properly. Any delay in investing the property means that the beneficiaries can sue for breach of trust. Retirement of trustees. A trustee may retire in 4 ways: taking advantage of an express trust, express clause in the trust. He could be discharged under Section 46 of the Act. He could obtain the consent of all the beneficiaries, making sure that they're all sui juris and absolutely entitled to trust property, or he could obtain the court approval. Now, a trustee can retire without a replacement. At least 2 individual trustees or a trust company remain to administer the trust, and the remaining trustees and any other person empowered to appoint new trustees consent by deed to his retirement. The trustee executes a deed of retirement. So retirement under order of the court. The court may discharge a trustee under Section 48 only where it is willing to replace the trustee within the power given by the section. The court also has an inherent power to discharge a trustee without a replacement in an action to administer the trust. This may occur where the trustee is not able to retire under the section, or the trustee cannot obtain the requisite consents. A trustee can also be removed from trusteeship out of court, where he remains outside the jurisdiction for a period of 12 months or more, or he just refuses to act, or he is unfit or incapable of acting. He may also be removed and replaced by the court. In addition, the court has an inherent power to remove a trustee without replacement under the principle in Letterstead versus Brothers, which is that a trustee may be removed if his continuance in office would be prejudicial to the due performance of the trust. And so, the interests of the beneficiaries. Fraud, bankruptcy, or gross incompetence would be grounds for removal, but it's not necessary for those seeking the trustee's removal to show misconduct on the part of the trustee. It is sufficient if there's a friction between the trustees or beneficiaries or lack of confidence in the trustee. In the case of D. Mercado versus City Trust, a Bahamian case, under the provisions of the trust deed, the corporate trustee had the power to terminate the trust and pay the capital over to the income beneficiaries in equal shares. The income beneficiaries requested such termination by letter to the trustees, setting out detailed reasons for the request. The trustee rejected the request in a perfunctory manner and after undue delay. The beneficiaries sought the removal of the trustee by the court on the ground that the relationship between the trustee and the beneficiary was unsatisfactory, and that such removal was in the interest of the beneficiaries. Chief Justice Judges said the principle to be applied in considering the removal of a trustees was discussed in the case of Letterstead. Quote, in exercising so delicate a jurisdiction as that of removing trustees, their lordships do not venture to lay down any general rule beyond the very broad principle that their main guide must be the welfare of the beneficiaries. Probably it is not possible to lay down any other definite rule in a manner so essentially dependent on details, often of great nicety. Earlier, their lordship had discussed the dearth of authority in this manner, in this area, and had agreed that in practice, once issues of character had been settled, once it was clear that the continuance of the trustee would be detrimental to the interests of the trust, even if for no other reason than the human infirmity would prevent those beneficially interested from working in harmony with the trustee is usually advised by his counsel to resign unless the trust instrument indicated contrary intention on the part of the settlor. So in this case, there were veiled allegations of breach and trust and other direct charge of incompetence. Understandably, these had to be resisted, and I find that they have been disproved. I do find, however, that the charge of unresponsiveness has been made out, and I am satisfied that the relationship between the income beneficiaries and the trustee is such that the interests of the beneficiaries are likely to be affected. The income beneficiaries are both form the record, competent and experienced as managing large assets, and the trust is likely to benefit from close collaboration between themselves and the trustee in whom they have full confidence. The trust instrument makes clear that the interests of the income beneficiaries are to be the primary concern of the trustees. Paragraph C of the 5th article reads, the power vested in the trustee under the foregoing provision of this article shall be exercised with primary regard for the interests of the income beneficiary of the particular trust, or to the extent the trustee shall deem appropriate, the interests of the members of her family and the interests of any other person shall be disregarded. In the circumstances, although I find that the allegations of incompetence and possible breach of trust have not been substantiated, I am satisfied that in the interest of the welfare of the beneficiaries, there should be a change. A more restrictive approach to the court's jurisdiction to remove a trustee was decided in the Bahamian case of Viso versus Chase Manhattan Bank. So this chapter on appointment of a trustee, when it's a new trust, when they can be removed, when they can be retired, and when the court is exercising its discretion, the consideration that it should take in place are all very important for a trustee. Any questions?
Ms. Archer,
Yes,
so in that case just now, because I a little confused.
go ahead.
So the judge granted the beneficiaries the right to
Yes.
remove the. So it looks as if the beneficiaries have, I know they have a lot of power, but they could come against the trustees at any time,
Yes,
even if they're not doing, let's just say they have an issue, they want their money now, even if it's not supposed to, if they're not supposed to get it now, or even if the trustees deem fit that they're not supposed to get it now, they can come against them and put something in court.
yes,
Oh, wow.
yes. Don't forget now, they have the right to information, which you will learn further down. But in conjunction with that right to information, the trustees have a duty to account. But if it is a discretionary trust, they cannot say how they came up with their deliberations, how they came up with who's getting $50 and who's getting $100. And so that's when they can come up together and say, guess what? I'm going to sue. So I have a case. I'll share with you all on the last, I'll see if I can send it to you this week. Let me see if I can locate it. I'll send it to you. We'll see where this beneficiary sued his father. He went to the trustees because he wanted more money. I gotta see if I can locate that. Because what his father did was his father turned around and said that he's terminating the trust. But he wanted more money. So what happens? But as a beneficiary, you have that right to sue for breach of trust. Either the trust is not being managed properly or it's not being administered properly. And so you sue.
But the only way the father could terminate that trust is if he was a protector or like a beneficiary of the trust, but he would still have to be, or if it was a revocable.
No, don't forget now if it's revocable.
Revocable trust, yeah.
Revocable trust, yes.
Yeah. Okay.
And some of them do that. When it's just them, let's say one parent, and they have 2 or 3 children, they'll make it revocable, which means that I will pay you during my lifetime. And if you decide to make me angry, I just stop it. So they do that. So yes,
And
you are paid. Go ahead.
in that case, if the monies aren't paid as yet, everything goes back to the peddler?
Mm-hmm.
Okay.
Yeah. Everything goes back. Remember, I told you a lot of, besides trusts, paying like that for wealth preservation. Don't forget now, you gotta have the trust set up whereby your children are beneficiaries, but they're not paid until after your death. So during your lifetime, you receive the benefits, and then upon your death, then your children receive it.
So you know how sometimes you hear things like the estate went to the dog or something strange. Could the children or let's just say wife or something, could they take that to court?
On
They're
what
not the
grounds, though?
beneficiary.
No. The only way that could go to court is if you're going to say that the trust was not properly constituted.
So they just would have to find flaw in it in order to take it to court.
Yeah.
Okay.
Yeah, there's no other way you could get it. No other way. Mm-mm.
So let's just say, in the case of when they leave things for a dog, like how does that work? And it would be like a follow-up will in after the dog or the strange person they met and they left all their money to. Would it be something that follows up and say after this person has passed away, this is what I want done?
No, they give you, or they normally put options. Okay, so let's say I say, I am the beneficiary. Upon my death, let's say I name my 3 children. If my 3 children are dead, then I will send it to charity.
Okay.
That's how they word it. Yeah, they word it like that. That's how it's worded. I'm trying to find the one now for the animals. Let me see if I could find it. Because there are some rules when you leave things to animals also. There are rules everywhere when it comes to law. So let's just say if you leave property for animals, so it's for a charitable purpose. What'll happen is if it can't be delivered in that way, the court will normally order a scheme whereby it can be delivered for charitable purposes. So people do leave things for animals, animal shelter and different things. So let's say in this case here, Reimer, the testator gave a legacy, quote, to the rector for the time being of St. Thomas Seminary for the education of priests in the Diocese of Westminster for the purposes of such seminary, end quote. Shortly before the testator's death, the seminary had been closed, the building sold, and the students transferred to another seminary 1,000 miles away. It was held that the legacy lapsed and fell into residue. However, it has been pointed out that the courts have gone very far in the decided cases to resist the conclusion that a legacy to a charitable institution lapses, and a number of very refined arguments are being found acceptable with a view to avoiding the conclusion. So you see that the courts will try to do whatever is necessary in order, when there's a charity, to try and see as if they can salvage it. You all sound as if you all think your family members may do the same thing. Leave funds to charity. No, yes.
Say that again.
I said it sounded based on the questions as if one of you feel as if your family member may decide to leave things to charity rather than to leave it to you all. That's how it sounded.
But what happens in the event that I didn't leave a will and I didn't do a trust?
Uh-huh.
So that's what they call the heirshipping.
No, heirship. Heirship, it refers to persons from a civil jurisdiction. You know what I mean by civil?
I was about to ask you to explain that.
Okay, so we are a common law jurisdiction, which means we follow English law.
Mm-hmm.
We have countries that follow a different law. So places like, let me see if I can get the civil jurisdiction on top of my head. I'm trying to think of which Latin American is civil. France. I think France is civil. France is civil. Who else is civil? some of the Latin American countries are civil law too, which means they don't follow common law in terms of precedents. They have a different law from us altogether. So persons from civil jurisdiction, they would come to a common law jurisdiction, whereby they can dispose of their assets as they see fit. But in the civil jurisdiction, the law decides how your assets are to be distributed. So here you are in a common law jurisdiction. If you were to die and you didn't write a will, you didn't create a trust, then the Inheritance Act would kick in, of the Bahamas. And in that act, the government actually states how your money is to be distributed. You heard about that, right?
Yeah, I think I have a little bit of information on it. But so that's where they used to do like next of kin, and they changed it from being the male, right?
Yes, yes.
So
if you-
everyone would get it. Go ahead, sorry.
No, go ahead. So, okay, so are you married?
Yes.
So if you're married and you die, you have no children, he gets all.
The spouse would be first.
Yes. He gets all, not first, he gets all.
Mm-hmm.
If you have no children, he gets all.
Mm-hmm.
If you have children, he gets half. And the other half go to your children to be divided equally between them.
Okay.
And then it goes down the line. If you have no children and no husband, then and only one, okay, if you have no husband, one child, that one child takes all. If you have no husband, no children, then it will go to your grandchildren. If you have no husband, no children, no grandchildren, then it goes to your mother and your father. And if your mother and father is dead, then it goes to your brothers and sisters. Yeah.
Okay.
That's equally to your brothers and sisters?
Yes. In equal shares.
So what about children that were not born in the marriage or
Doesn't matter. Doesn't matter. Children are children. Under the status of children are children. And then there are different rules for a child to prove that they are a child of the family. Or they are a child of whomever, the mother or the father. There are tests that can be taken. And then there are affidavits that can be written to show how the person supported or visited that person, that child, or came and took that child out for a ride or for ice cream or whatever. That's why a lot of people get surprises.
So even in death, they could get the shock.
Yes.
Wow.
Yeah. And then the same thing, remember when we spoke about half secret trust and secret trust.
Mm-hmm.
And you may not, as a spouse, you may not even know at all, because you know that Charlie is his best friend. But Charlie's not going to tell you that 50,000 or 40,000 left for me is for his child. Or it could be the other way around. He died without a will, and now all of his other children are coming forward that you know nothing about. So it can happen that way too.
Wow. So then what would happen in that case? Like what would be, that's a lot.
What you mean? Which one? That the
So,
children come forward?
Mm-hmm.
Well, they would get a lawyer, and then each one of them would prove that they are a child. of the deceased, and they go before the court, you would get half, and they would split the other half.
I guess it would be interesting if I'm married with no children
Mhm.
and I'm thinking I'm getting 100% if my husband dies and then 10 children show up.
Exactly.
Yep.
Exactly.
That's the exact same way I'm thinking.
Yep. Or the other way around. Your mother is already passed, so there's just your father. He's very wealthy. You know, it's only you and your sister. Then he passes, and you find out it's you, your sister, and 10 more. So I know of a case where the mother died, the father was living, very wealthy. He did have 2 children, and the assets were in a company. And what the son did was, as the father got sick, he transferred everything. He had his father transfer everything from him, from the father, to the son and daughter. So when the father died, there was nothing left in his name. That's wicked.
Oh, so that the children, let's just say if it was secret, if there were children that they weren't aware of, they still couldn't come for anything because it would no longer be the dad's own. It would
Exactly. Yeah, everything was transferred during his lifetime. So when he died, all of those other children that he had, which was quite a bit, went forward, and there were no assets. Mm-hmm. But there is some hope for wives whose husband put their properties in companies, because there have been cases now going before the court where husbands try to put all their assets in companies so that when there is a divorce, the wife will not receive anything from him. And there have been cases where the courts have gone behind, not behind the companies, but looked at it and say, your wife contributed towards you during your lifetime, and so she should be entitled to a part of whatever you obtained during the marriage, especially if those companies are making money. Any more questions? You're still thinking it?
I have a question, Ms. Archer,
Go
going
ahead.
back to a sham trust,
Mhm.
because you touched on today about appointing or nominating persons as trustees. It kind of made me think about if a settlor has himself as a beneficiary, he has rights in the trust. If the settlor appoints himself as a protector and gives the provisions that the protector has to approve certain things or whatever that the trustee does, and then the settlor also retains the authority or the powers to change the trustee, wouldn't that start to border on a sham trust because the settlor still has so much power in the trust?
It depends on how he wields that power.
Okay,
Yeah, because it's not just the power, it's the control.
okay,
Yeah. So if he only does these things when the occasion arises, it's fine. But if he starts to dictate to the trustees, then he has too much control.
okay, I understand. Thank you.
Okay.
Could a settler be a beneficiary as well as a protector?
Yes. Remember now, being a beneficiary is just so he can receive some income. Being a protector means that he can still have some say and guide how the trust is being operated. And without being a beneficiary, he cannot sue.
Okay.
Yeah, he'll have no say at all. So it sounds as if you all have this, you have this down pat. My exam should be rather difficult. I didn't hear anything.
Why should it be difficult?
Because you all are very sharp.
Mm-mm.
It's a sharp crew.
No. Let's.
Remember, we just starting now.
Yeah. I have to make sure you get those pages that are missing.
I'm just taken aback with trying to like remember the cases. Because honestly, when I read that, I just read the name and skip straight over.
No. Even if you don't remember the name, you have to remember the facts.
Okay.
Yeah, the name is not as important as knowing the facts. And I would say from now, you need to start reading from this chapter on and try to put the cases that goes with the principles. Because as you move on further, there are more cases. And in an exam, you get points when you're able to apply the cases to your answers. So you hate to answer a question in law and lose about 5 to 6 points just because you couldn't remember at least the story. Just the story itself is sufficient for you to get a point or two. But if you don't put anything at all, then you lose those points.
Well, we have a guide for us to basically know exactly what we need to be studying. Like what
Yes,
our answers should
on the
be
last class. On the last class.
Okay.
On the last class, I will tell you what areas to study for.
Okay.
So by that time, when we come to the last class, if you look on your schedule, I'm at the last class on the 2nd of April. By that time, I would have already written the exam. So when we meet, I will tell you, this is where we are focusing. So when I tell, if I tell you, we're going to be focusing on the removal of a trustee. So the question will be around removal of the trustee. So you know exactly where to go. You know which case applies to that. You know which section applies to that. And that's what I expect to see when you answer the question. So if I tell you the question is on replacement, when you get in the exam, you shouldn't be writing about removal. If I say the question is on being a trustee just appointed to a brand new trust, what do you do? Or a trust was transferred to your firm. So that means it's new to you. What do you do? You shouldn't be writing to me about surviving trustee because I've already given you the area to study. I find students do that a lot. I've already gone through and I told you exactly the areas that are coming. And then they write about something totally different. So there's no need to panic yet.
Will the exam be at the school?
Yes. Mhm. On the 9th. Which is around the corner. You have a whole month and a half to go.
I feel like this tomorrow.
No, it's not. You have a month and a half to go. Today is only the 5th. You have what? 6, 1, 2, 3, 4, 5, 6, 7.
We'll be at the class at the end of the class in the next 2 weeks.
Yeah, that's true too. Yeah, but I'll have the exam written and then you'll know exactly what's coming. And then you can study from then. But don't wait until you come on the 2nd to then open your book to begin studying. That's what I'm saying to you. Start each day, start to review it so that when you come on the last day, you don't have to be scribbling like, what do you mean? Like, I don't understand. Because if you've been reading your chapters, you know exactly when I say something, where to look for your answers. Otherwise, you're going to be scrambling all over the place. And then you can start to put things together afterwards. And you'll be answering the question, but a lot of things that are not relevant. Confusing yourself. Because at the end of the day, you're going to say, well, how come I didn't get full points? And then when you look at it, you say, oh, I shouldn't have talked about this. This was not about that. That's not what she said. No, it wasn't that. It was this. So start to go over your notes now after each class, so it is fresh in your mind. So when we meet on the 2nd, you know exactly what to do. Okay? Stress not. And read them in conjunction with the trustee, because I may decide to put a clause from order the trustee in it, in the exam. All right?
Okay.
All
Okay,
right. So happy studying, and I'll see you all on the 2nd.
Okay.
and we can still come to you with questions via email, right? If with things we
Yes.
don't understand.
Uh-huh.
Okay,
That's fine. That's fine.
okay, thank you.
Okay. All right.
Thank you.
Bye.
You're welcome.